Good morning, everybody. This is Advocate Tanya Karnwal. I'm the Managing Associate at Harshit Batra and Associates. I'll be conducting your today's session on the rights and obligations of the builders and the allottees as well as the real estate agents. Basically, we'll be covering all the stakeholders which are covered under the RERA Act. I hope I'm audible to everybody.
You're audible and visible, ma'am.
All right, perfect. Allow me one moment. I'll just go ahead and share a PowerPoint presentation with everybody, which will, I hope, enable everyone to understand the very basic concept that revolves around the Act and about the stakeholders in general. Allow me one moment, please.
Right, ma'am. And in the meanwhile, guys, I'm sharing a link to the landing page to the whole course. Please visit the landing page, look for the details on the course, and join us in case you have anything that I can help you with. Please get in touch with me on my digits that I'll share in the chat. Also, please try to stay on video so we can make the session interactive. And we leave the session with a handful. Also, you can keep sharing your questions in the chat box. We'll get them addressed at the end of the session. I hope my video and audio is clear because I don't have proper internet right now.
Right, Raghav, you're audible. Should we begin? If everybody is there.
Hanji, ma'am, when you're ready.
All right. Right. So as I was just saying that the today's session will be revolving around the rights and obligations of all the stakeholders in RERA. What do I mean when I say rights and obligations and the stakeholders? These are the three very important words that as I believe everybody here are RERA practitioners or I believe budding lawyers. These three keywords will in order to ascertain and go into the depths and understand the very peculiarities of the act. These are the three very main keywords that in understanding of which it will help you in the long run in gaining an insight as to what and where all the RERA can enlighten and help all the stakeholders. Now when I speak about stakeholders, who all are the stakeholders in RERA? The main three stakeholders in RERA are the real estate agent, the promoter, and the allottees. Now, beginning with the one of the most common stakeholder that everybody would be aware of is the real estate builder, the promoter. Promoter is anybody who develops the building or the project. In going forward in this particular slide, we'll see in detail as to who is a particular promoter, who is an allottee, and who is a real estate agent. However, there is a small gap in the act in the legislature to allow some speculations that can be ascertained with respect to a fourth stakeholder, which are the landowners. And the landowners are particularly different from promoters. There is no particular definition of the landowners under the RERA Act. However, there's some speculations that can be derived from the Act itself. Now, the other two main words that we derive from today's session are the rights and the obligations. It is incredibly essential to ascertain what are the rights and obligations of any particular individual concerning any particular legislature. It is always in order to move further. If you're filing a case tomorrow, you will always have to ascertain what are the rights that are need to be protected of a particular individual or an entity, and what are the obligations that a person has to ensure to comply with. Now, moving further, who is an allottee? in a general sense of terms, an allotee is any person who buys a plot or a prop or a unit or an apartment. Now, when I say a unit, it actually covers an apartment as well and a plot as well. However, the Act distinguishes the in all the three words through its model RERA agreement, which are incorporated in all of the state model RERA rules. An allotee, the definition of an allotee has been defined under Section 2A of the RERA Act. It includes two types of allottees. One is the original allottees, and two is the subsequent allottees. Any person who originally buys a unit first hand from the builder and maybe enters into say a booking form or an expression of interest is a person who can be rendered as an allotee. Different Veredas have given different judgments on who an allotee is and at what stage can an allotee be determined. By merely executing a booking form cannot determine the person who's giving the booking form to be an allotee. That is what the definition of an allotee covers. It essentially says that a person who has been allotted or sold. By that, the reference that the Act derives is of that of the allotment letter, which is followed after the booking form, as well as a builder buyer agreement, which is further followed after the allotment letter. Now, a second class of allotee that is covered is within the definition of allottees are the association of allottees. When a project is sold to a capacity or to more than two-third of the capacity of individuals, those individuals come together and form an association that can or cannot be registered under various other acts like the Cooperative Societies Act and other association acts that are prevalent in the respective states. Those association of allottees, when they come together, they can also become part of the definition of an allotee. Now, covering to the third type of allottees were the subsequent allottees. Who are subsequent allottees? Subsequent allottee is any person who purchases a unit in the real estate market. I believe everybody here would have seen a number of circumstances where a person buys a unit from another individual who's already an allottee. So that is where we buy a unit in the market and not from the builder directly. That is where the definition of a subsequent allottee comes into picture. The standing of a subsequent allottee and that of an original allottee, in a general sense, is on the same footing. However, the standing may differ from state to state basis. I'm unaware as to from which all states our today's participants are. If I could get a knowledge of that, it'll help me better in telling you all a little detail about that particular state as to what that state tells that who the subsequent allottees are. Everybody, if everybody is listening here and can drop the same in the chat box, and I'll be able to certain that. So now moving further, to the rights and the duties of an allotee. The main section that covers the essential rights and the duties of the allotee is Section 19 of the RERA Act. Now, taking an understanding in the general sense again, an allotee is a person who buys the unit, who buys a plot. Now, considering ourselves as allotee, what is the main essential thing that we need to know, right? We are all aware, being either lawyers or being law students, we're all aware that the right to information is one of the very fundamental rights that every individual is entitled to. So the same flows within the RERA Act as well. The legislature had incorporated a very detailed description as to what all informations should always be available to all the allottees of the project. Now that includes the detailed information of the unit, the particular unit that the individual is purchasing, as well as the detailed information of the entire project. Now, when I say project, I mean the details of the building plans, which are the layout plans and the sanction plans and the site plans, as well as all the details of the essential services. Essential services are any services without which the inhabitability of the unit cannot be asserted. For instance, if I take a unit today, And if I don't have water in the unit, I will not be able to use the unit. So that makes water as an essential services. Similarly, if I don't have electricity in the unit, then that makes electricity as an essential service in the unit. So with respect to all the essential services that are there, that are being provided by that particular state, all of those essential services and the details of all those services, the sanction plans of all those services, and essentially the service estimates, as we call in the reference of the terms as used by the competent authorities, the details of all these services need to be made available to the allottees. A number of times in the if I move a little ahead and talk in the practical scenario, a number of times these services are not made available to the allottees by the builders themselves. However, the allottees always have a right to ask for these services, the details of these services at any point in time from the builder. Now, apart from these services, the what connects the builder's need of buying the unit with the services is the schedule of development. If I'm buying, if say I am in a lottery and I'm investing in a unit, then I should be given the knowledge of how the development of the unit is proceeding. If the payment plan that I'm buying the unit is a construction link payment plan, in that circumstance, an additional knowledge that the allottee should always be given is that of the stage wise schedule of completion, along with the sorry stage wise schedule of completion of the unit, along with the completion of the essential services. Apart from having these information, the third and the fourth main rights that are protected under the act, the RERA Act, towards the allottees are the right of the allottee to claim possession along with interest, and to claim refund along with interest and compensation. Whenever an allottee books a unit, it is his right to get the unit within the specified timeline that has been promised by the builder and has been agreed to by the allottee, either in the allotment letter or in the builder buyer agreement, or in the circumstance the builder fails to give the handover of the unit so allotted in that particular time span. In that circumstance, another right of an allotee develops, which is known as the right to claim refund along with interest and compensation. This in itself ascertains the damages that the allotee can claim in the circumstance the builder fails to hand over the unit to the allotee for any reason whatsoever. In today's time, if I'm standing at the end of 2024, in today's time, the RERA Act has also evolved a little through the judicial pronouncements. A number of instances that could have barred the allottees from claiming this right of refund has now been very well clarified by the Honorable Supreme Court as well. And this right has been known to be unequivocal and has been very well protected by various judgments that have been passed in various different courts. Moving further, there are other rights of the allottees as well, which are not enumerated in Section 19, which is specifically destined to be the provision for the rights and duties of the allottees. Whenever a builder fails to complete the project, any person, any individual, or an authority in a suo motu action can always initiate proceedings to seek the revival of the project or to make a plan as to how the project is deemed to be completed. In such a circumstance, the first priority that is always given is to the association of allottees. The association of allottees is called into the picture in that circumstance, and they are asked if whether or not they would like to continue the and complete the remaining development which the promoter has failed to complete. In that circumstance, the primary right of the association of allottees is that of right of refusal. Allottees can, coming together as an association, refuse to develop the remaining project, and in that circumstance, it falls upon the authority and the state government to see as to where and who is the concerned person who should take over the project, with what finances, and all details that follow. With respect to allottees, the right restricted is that of refusal in such circumstance. In a similar situation, whenever there are any structural alterations in the project for any reason, whether they're architectural or structural reasons, or whether there's change in building plans, in that circumstance, one of the very core right of the allottees is with respect to consent. I'm sure everybody here would already be aware of the inherent meaning and understanding of the term consent, which flows from the Indian Contracts Act. Without consent, no a bilateral contract cannot proceed further. Any changes in the bilateral contract can also not proceed further. Whenever a builder proceeds to take a revision in the building plan from the competent authority, or whether a builder acts on deviating from the building plan for either architectural reasons or structural reasons, in such a circumstance, the consent of the allottees is mandated under Section 14(2) of the RERA Act. Whenever the one of the another rights that have been ascertained under the RERA Act is that of the transfer. Whenever in the circumstance where the association of allottees comes forward and gives their right of refusal, in that circumstance, somebody has to develop the project, right? In that circumstance, whenever the project transfers to any such third party, the allottees are required to give their consent. Two-third two-third of the allottees' consent is mandated for such transfer of any project. Allottees, in case of any breach of any of the rights, as we discussed herein, in case of any breach, the allottees have a right to move before the authority under Section 31 of the Act, which is the first instance or the first court, which in civil courts we refer to as the trial courts. However, here being summary proceedings, we refer to them as either the authority or the adjudicating officer. So that is another right that the Act seems to be have protected. Now, moving further, other rights of the allottees that are there are with respect to with respect to participation of all the allottees in the association of allottees and the formation of the cooperative societies. Now, there is no particular distinction in the rights and the duties of the allottees in the entire Act. However, if we read Section 19 to we get a very peculiar understanding as to how to distinguish the rights and the duties. It is the allottee's right to be a part of the association. However, on the same hand, it is also the allottee's duty to participate in the formation of the association of allottees. These are the proceedings that are also carried on by the allottees and may also be initiated by the builders. That depends, as the case may be. All of these things can happen at the same time. Apart from that, it is also one of the duties of the allottees to ensure to make all the payments as per the builder buyer agreement, as per the agreed schedules of the builder buyer agreement. Now, if here we were to link with the previous slide, as we just discussed, one of the rights of the allottees is to have the stage of development. Now we'll move forward with a small example here. If an allottee X buys a unit or is allotted a unit in a particular project and he agrees to a construction link plan, say he has to pay out of rupees 100, which is the total sales price, he has to pay rupees 10 at the time of development of the first floor and rupees 15 at the time of development of the second floor. It is the right of the allottees to have those information as to how and when the first floor has developed and the second floor has been developed or constructed. At the same time, the duty of the allottee is to ensure to make the payment of that rupees 10 at the time of development of the first floor and of rupees 15 at the time of development of the second floor. So in a way, what we see is that the rights and the obligations of the allottees go hand in hand. As long as the allottee is given the information about the development of the project, the demand can be raised by the builder as per the agreed terms. On the event of such a demand having been raised, it becomes a duty of the allottee to make that payment. In case of failure of the allottee to make that payments, further rights of the promoters are come into the play with respect to either termination or sending or in charging any interest, which again forms into the part of the duties of the allottees. In case the allottee fails to make any payment which has previously been agreed before, again we come back to the essence of consent that we discussed previously. Any payment that I have consented to make before and I fail to make that payment, in such a circumstance, an interest will be levied upon me. The difference in the pre-RERA and the post-RERA tenure here is that pre-RERA, such interest used to be at a very exorbitant rate of either 18% or 24%, or any other such percent as the builder feels to levy. However, in today's time, when the RERA has become effective, the rate of interest that is chargeable from the allottees is as may be prescribed by either of the state governments. The state governments determine what is this rate. In a number of states, that percentage has been set to be State Bank of India's MCLR plus either 1% or 2%. And that may differ from state to state. For instance, in Haryana, it is plus 2%, in UP, it is plus 1, in Maharashtra, it is plus 2. In order to ascertain what is the specific rate of interest, we'll have to take a reference to the particular state rules and regulations. Moving further, it is also the duty of the allottee to get the conveyance deed executed and to take the possession of the apartment within 60 days of receipt of the occupation certificate. If there's an order passed by the authority or by the appellate tribunal, it also falls upon the duties of the allottee to ensure to comply with such an order. In case of any order that has always passed, there are only two circumstances that a person may have: either to comply with the order, or in case of any grievance against the order, to file an appeal against those orders. We will discuss in detail about appeals in our further classes. However, here we're restricting ourselves to know that okay, the allottee have a right to file an appeal and a duty to comply with the orders. And we'll move further with respect to the second stakeholder under the RERA Act, which is the promoter. Now, it is incredibly pertinent to ascertain as to who is the promoter. In a number of circumstances, a query may be raised as to whether a person developing a project is a promoter or not. A very detailed view on this point has been given by the legislature under Section 2ZK of the Act. If we read a bare reading of the section, we seem to understand that all of the sub clauses seem to be similar in one sense or the other. However, to give a core understanding of the fact as to who is the promoter, we need to ascertain only three things. One is any person who may construct a plot, may construct in a commercial unit, may construct an apartment, or may construct a building, may construct floors, may construct anything whatsoever. Any person who either construct or causes to construct. Any of the people who fall under these two categories are always referred to as promoter. Now, one of the second and rather the more pertinent description as to determine as to who is a promoter is the aspect of selling. When a promoter constructs a building, an independent building, an apartment, or a plot, or anything whatsoever, the intent of that development is to further sell the unit or the apartment or the building as a whole or the project as a whole. In the circumstance, any person or an entity constructs with an intention to sell, they fall within the definition of the 2ZK Act. When I say that they can develop a plot, what is ascertained by that is not the construction on the plot, rather the development of the project plot and ensuring the presence of essential services on the plot, which essentially means assuring that the water lines have been levied, the electricity connections availability are there, or the meter connection is there, the sanitation is there, the storm water connection is there, and so on and so forth. Now, it does not necessarily mean that only a company can develop. It can either be a person, a partnership firm, a apex state level, or cooperating housing society, or any primary cooperating housing society, or any members of the society who come together and develop that particular society for the usage of those members only. All of these people come within the definition of a promoter. Now, any contractor or a colonizer can also be referred to as a developer, as long as he is claiming to be the power of attorney holder of the land on which the apartment is being constructed. Now, this particular subclause read with the exception provided under 2ZK, which essentially means that where the person who constructs or converts the building into apartments or plots for sale, or who sells apartments or plots for sale, are different from the person who own the land, are deemed to be promoters. In such a circumstance, what we see essentially is that the derivation of a fourth stakeholder, which is the landowner, in very recent past, rather in 2024 only, the rights and the assertioning of landowners as a promoter within the meaning of the act has been upheld by the Honorable Supreme Court as well. It has been done after giving reference to a detailed reading of the entire provision of Section 2ZK and the duties and the obligations that the landowner share with the promoter. We'll read further in this slide. We'll understand how a landowner is also different from the promoters. Moving further, with respect to the obligations of the real estate promoters, the very first obligation is with respect to the registration. At the time of the implementation of the Act in 2016, the registration of a real estate project was mandated by the legislature under Section 3 of the Act. In order to register such a project, the details of the entire project were required to be submitted by every promoter before the authority. Now, there are two types of project that came into role at the time of implementation of the Act. One was the ongoing projects, and second was the new projects. Ongoing projects are any projects that were already in play or had not received their completion certificate prior to the coming of the RERA Act into the picture. This definition of ongoing projects is not ascertained under the Act, and we may refer the state rules to understand what is the specific definition that that particular state has given while giving a reference to the ongoing projects. In any circumstance, as long as the project is being developed, it is required to be registered before the authority. At the time of registration, all the details of the project with respect to all the details of the units, the allottees, the previously developed projects, all the sanction plans, specifications, building plans, layout plans, and all the encumbrances on the project as well as charges need to be disclosed before the authority. It is after discussing and after having a look at all of these documents and information that is provided by a promoter that the authority ascertains whether the project should be given a registration or not. In the circumstance authority decides to not register the project, it gives its reasons and details which follow. There are certain projects which do not require registration. Wherever any person constructs or causes to be construct any development which does not exceeds 500 square meters, or the number of apartments do not exceed 8. In such circumstance, no registration of the project is required. That is an exception that has been very, very well enumerated in the Act itself. Neither any registration is required in case of any repair or redevelopment of a previously developed project. It has been held in various circumstances as to where the development of a project is required and where not required. Sorry. One such circumstance has been noted here, and following in very recent past, it has been noted that the provisions of Section 3 are mandatory in nature, which makes one of the duties of the promoter with respect to registration as a mandatory act and cannot be left on to the whims and fancies of the promoter. Moving further, with respect to the rights of the promoters, of course, being a stakeholder, even though promoter may a number of times be considered to be one of the more powerful stakeholder in the RERA Act, the rights of every individual are very well protected under the Act. Now, the rights of the promoters and the duties of the allottees again go hand in hand. There is no provision under the Act that specifies or points out the specific rights of the promoter. However, We can determine as to what are the rights by having a look at the duties of the allottees again. As we just discussed, that one of the duties of the allottees was to make timely payments as per the agreed payment plans. In such a circumstance, it becomes the right of the promoter to take that payment from the allottees. At that instance, again, when a builder buyer agreement is registered, the payment of stamp duty and other ground rents or other charges, whether there are any other municipal charges, are also necessitated. In such a circumstance, it becomes a right of the promoter to have all of these details. As we discussed a few moments ago, that we have an uncontested that all the allottees have a duty to participate in the association of allottees formation. In such a circumstance, it becomes the right of the promoter to have all the allottees who are there in the project to have an uncontested participation in form of a formation of the association of the allottees. This is, of course, after considering all the state acts and the rules and the regulations that are in picture with respect to formation of any association in a similar circumstance. While it is the right of an allottee and the duty of an allottee to take the possession and execute the conveyance deed, it also becomes the right of the promoter to hand over to ensure to have the allottee to take the possession of the apartment in a bona fide manner and in a timely manner as well. The promoter's right to approach the concerned authority, whether be it the learned authority or the adjudicating officer or the appellate tribunal, has been protected under the RERA Act, which was not the circumstance prior to the implementation of the RERA Act. Prior to the implementation of the RERA Act, what the only provisions that were available with respect to the promoters of filing any case were with respect to initiation of a civil suit, which I'm sure everybody here is aware that takes a rather substantial amount of time and determination. However, after the implementation of the RERA Act, this right has been protected as one under Section 31, which entitles any aggrieved to file a complaint before the authority. Such an aggrieved can be a promoter as well if any of the rights of the promoters are seen to have been dishonored or have been not complied with by the allottees. Now, moving further with respect to the duties of the allottees, when the rights of the promoters are not ascertained under the RERA Act, but duties of the promoters are very well entailed and descriptive in the Act itself. One of the first duties that we read at the beginning of the slide with respect to promoters were with respect of the registration. The prime aspect of registration follows with the duties of the promoter. Apart from that, it is also a duty of the promoter to not put any false statement or information or advertisement in any of the prospectus. It is again a duty of the promoter not to advertise, market, sell, or book, or offer for sale, or invite any person to purchase the unit without having registered the project. In a number of circumstances, being practicing advocates, we must have seen a number of real estate a number of authorities giving the registration certificates to the real estate promoters on certain conditions. Certain those conditions can always and have a number of times been seen to be included to be with respect to submission of a particular sanction plan or a building plan, prior to which no sale or no offer for sale is deemed to be permitted. The state RERA authorities have also given out their own regulations in detail as to when an advertisement can be done by a promoter or an agent for that matter, and when the same cannot be done. The promoter is also obligated to ensure to adhere to the sanction plans and all the project specifications which are approved by the competent authorities of that particular state. Once the promoter completes the project, it is the duty of the promoter to ensure to obtain the completion certificate as well as the occupation certificate. In case the unit is being developed on a leasehold hand, in such a circumstance, the promoter obtains a lease certificate and also executes the relevant bilateral agreement or a tripartite agreement, as the case may be, with the allottees. Without the consent of the allottees, the promoter is obligated not to create any charge or mortgage on either the apartment or the project as a whole. All of these details are always made available to the authority as well as to the allottee. So all details with respect to project are always made available by the promoter on the registered website as well as on the details of the state authorities web page. Now moving further, the promoter is also entitled to take all the necessary insurances with respect to all the documents as well as the entire project as a whole. In the circumstance, the promoter has executed a builder buyer agreement after the execution of the RERA Act. The promoter cannot accept more than 10% payment before executing such an agreement. Now, now seeing this in light of the differentiation of on a pre-RERA and a post-RERA tenure, if in a circumstance the promoter has taken more than 10% of the total sales price prior to the execution of the agreement, that does not mean that there has been any violation of either of the provisions of the Act or specifically Section 13 of the Act. It is only after the implementation of the Act that the promoter cannot accept more than 10% of the payment as advances, which are referred to as earnest money, prior to the execution of the agreement. The promoter is entitled to maintain all the essential services, which again fall into water, sanitation, electricity, stormwater, etc., till the entire project is delivered. Now, not only the promoter has to deliver the unit to the specific allottee, but also has to deliver the entire project as a whole to the association of the allottees. That handover is also mandated under the Act. Once the promoter gets the registration of its development, after the registration, the relevant concerned state RERAs have given their specific details as to how the bank accounts of a particular promoter have to function. The one of the mandatory nature that has been seen in all of the state RERAs is with respect to creation of a 70% account, which is the main escrow account, that is the builder's escrow account, with which the all the construction cost and all the land cost are taken out of. All the payments that the allottees make from time to time, of those payments 70% of the accounts are always mandated in such a 70% escrow account, which is further used for the construction of the project. Apart from these, of course, one of the again duties that fall upon the builder, which also was one of the rights of the builders, is with respect to the conveyance of the unit, which respects to the title transfer of the title of the unit from the promoter to the allottee, or in case of a joint development agreement with the landowner, in such a circumstance from the landowner through the promoter to the allottee. Moving further, the the third stakeholder that falls within the RERA Act is the real estate agent. There are primarily two responsibilities of the real estate agents, and these are the agents that we may most commonly call as brokers in the general parlance. Two main aspects associated with registration involving a real estate agent are to facilitate and engage only in the projects that have been registered before the authority, and to get themselves also registered as real estate agent. It is essential for a real estate agent to be registered under the Act, for which he is entitled to make an application in the specified format to the concerned RERA authority. There is in the respective state authorities have given a particular timeline within which they will either accept or reject the form of such a real estate agent from being registered. In case of rejection of such form, an opportunity is always given to the real estate agent to being heard, which forms one of the core principles of the principles of natural justice. If in the circumstance a particular real estate agent gets a reply on does not either gets his application accepted or rejected in that particular time period specified by the particular state legislature, In that circumstance, the real estate agent is considered to be have a deemed registration, which is very well enumerated in the Act as well. The entire law regarding the necessitated as well as the mandatory nature of a real estate agent to get registered has been noted by all the authorities. One such circumstance has also been enumerated here. We'll move further. The duties of the real estate agent. Now, the duty of the real estate agent is only to uh, hi, am I audible to everybody?
हाँ जी मैम ऑडिबल.
I believe I had some technical difficulties. I had to rejoin. Uh, Allow me one moment. We'll just take start from where we left off.
Sure मैम.
Raghav, I think I'm not able to share my screen anymore. If you could look into that. And meanwhile, if anybody has any questions with what we've discussed till now, we can take that up.
Ma'am, please try now.
Right. So as we were just discussing that one of the duties of the real estate agents is with respect to the registration and to maintain all the records as well as the documents that are necessitated by the concerned state authorities, as well as maintaining of his books and accounts. The last stakeholder that has been not very well defined under the act is the landowner. As we discussed at the beginning of the session, that landowners are nowhere defined under the act, and it is only the three stakeholders that have been defined. However, a small reference can be taken from the section 2 of the act, where we discussed that a person who causes to construct and a person who has been differentiated from a person who sells the unit in question. In such a circumstance, where two distinction has been made from a person who develops and the person who sells, in such a circumstance, that is where a small, by implication, the definition of a landowner can very well be asserted. If there are any questions that anybody has had till now, we can take them up.
Guys, use your mics, please. If you have a question, you can share it. And if you don't have a question, please tell us that it's clear. I think we can continue on.
So with that, we concluded the three main stakeholders under the RERA Act, and as well as the landowners incorporation by implication under the RERA Act. I believe Miss Nandini wants to one second. Miss Nandini has asked to throw more light on the joint venture projects. What happens in case of a joint venture projects is that there is a person who owns the land, who's known as the landowner. There is a separate person or an entity who develops the land. When both these two entities come together and enter into an agreement, they are referred to as joint development agreements. Joint venture, the term is not specifically what is used in the real estate parlance. It is rather a more of an investment term used in various other aspects, and more of a contracts term. The term that is rather more commonly used and will be more commonly seen by everybody is a joint development. Joint development agreements are agreements which are executed by these two different entities. Whenever they come together, they ascertain what are the different rights and liabilities of either of the parties. For instance, what is most commonly seen is that the landowners are entitled to get all the licenses, the permissions, and all the sanction plans and the drawings from the respective concerned state RERAs. And on the other hand, the promoters are obligated to develop the project or to carry out the construction in accordance with the plans so taken. They have a separate, there are two types of understandings that the landowners and the promoters can have under such joint developments, a collaboration or joint ventures also, if we may want to call them as so. One is the revenue sharing and second is the land sharing. It is solely upon the parties whether they want to, after the development of the project, whether they want to share the profit ratio amongst themselves, or whether they want to share a number of units with respect to both the parties. In such a circumstance, the reservation of a percentage of the project, the developed portion of the project to be specific, or the number of units is always agreed to between these parties at the time of execution of such joint ventures or joint development agreements. I hope this clarifies, Nandini. Does anybody else have any other question?
Guys, any questions? Ma'am, we don't have any questions in the chat as of yet, and I think others are clear. In case we have any questions or any follow-ups, so we can, share the questions with you on mail or WhatsApp, and we can have them addressed in the next class.
Definitely, definitely. Thank you
Right.
so much. Thank you, Raghav. Thank you, everybody else.
Thank you so much, ma'am. It was a great session. Enjoyed. And thank you everybody for joining us on another Sunday morning. We'll meet next on the next Sunday.
Right. Thank you so much. Thank you. Bye bye.
Thank you.